Welcome back. Audrey is not here tonight, so just three of you. Eventually we'll have all four consistently, but we'll get there eventually. Are there any questions from last night about equal protection and the affirmative action cases or the...
Yes, in one of your study guide questions, if there's any valid basis for the government to separate men and women based on biological traits. Do you have something in mind that the authors are thinking of when you pose those questions?
I don't know. I've posed questions in the past about bathrooms, which is an example that often comes up in changing rooms, right? Does the state have an interest in having biological males and biological females in separate changing facilities, say to the public pool or a high school gym locker room or something to that effect? Is modesty, some virtues like that, compelling enough interest to prevent it? Now, I think you told me yesterday that in the UK, the military is top to bottom integrated. Men and women shower in the same place.
Yeah.
They're showering in the same stalls?
Correct. Open.
Wow.
Open.
I mean, that's a foreign concept to me.
It is foreign.
I don't know if I could do it.
No.
Maybe I'm narrow-minded, but I don't know. Maybe you're more modern than I am, but that strikes me as a I don't even like changing in public, even with people of my even with other guys. It's just I don't like doing it in general. I usually change at home. Yeah, is that a good enough interest, or in the interest of equality, should that barrier also be torn down? Ginsburg has a line in the Virginia opinion where she suggests that certain modesty concerns for changing in dormitory facilities may be justified, but maybe even that's not enough anymore. I don't know. This though skips over the question about transgender individuals and a person who identifies, for example, as female. Can that person use a female bathroom, even if the person perhaps has certain male genitalia? And that's a somewhat common source of litigation now. It's not constitutional in the sense that it's a 14th Amendment case so far. These are statutory cases about whether federal laws prohibiting sex discrimination also embrace discrimination on the basis of gender identity. So these issues also do percolate. Anything else? Any other questions? Okay, let's move on. We sort of now go back in time. In the last few classes, we were focusing on equal protection. And we started with Brown, and we went through Loving, and we went through the affirmative action cases in the 70s, and we went through the affirmative action cases in the 90s, and the affirmative action cases in the 2000s, and we sprinkled in some gender cases there as well. Those cases sort of stand on their own with respect to the Equal Protection Clause. But today we sort of jump back in time. At the same era, or during the same era, that the courts were expanding the scope of equal protection doctrine, the courts were also developing due process clause doctrine. And we saw a flavor of it in Loving. If you recall, there were two parts to Loving. The first part was, does the ban on interracial marriage violate the Equal Protection Clause? The court says yes. And then the second part of Loving focused on the due process clause, right? Is there a so-called fundamental right to marriage? And does the Virginia law deprive the Lovings of that right? The court said yes. Very often, a law that discriminates on the basis of race will also violate a fundamental right. But there are some cases that are straight up due process cases, right? That don't really have an equal protection flavor to it. And those are the cases we have today, Griswold v. Connecticut and Roe v. Wade. to put these cases into context, we need to recall what happened during the Progressive Era and then what happened during the New Deal. During the Progressive Era, the court began to develop the doctrine that's now known as Substantive Due Process. Now, that term didn't exist in the early 20th century. It came around much later. But it generally describes the idea that the word liberty in the Due Process Clause has some sort of substance to it. And the courts can figure out what these unenumerated rights are. So think of cases like Lochner and like Atkins. Those decisions held that this word liberty includes the right of contract, and that courts could decide if some law was unreasonable, that it intruded on this right of contract too much. Some restrictions on contract were permissible, for example, women and their minimum wage or maximum hour laws, and other restrictions on contract were not permissible. So in Lochner, the Bake Shop Act with the limit on how many hours bakers could work, that law was unreasonable. But during this time, we also had other cases decided on the basis of what's now called substantive due process. For example, we have Meyer v. Nebraska. We have Pierce v. Society of Sisters. These were cases involving rights to raise your children, right to learn foreign languages, right to go to private schools. And the court made these fairly long lists of unenumerated rights that are not written down anywhere, that exist by virtue of the 14th Amendment. And if the government passes a law that violates these rights, then courts can intervene and halt the enforcement of those laws. So throughout the early 20th century, you had a fairly robust, it wasn't crazy, but you had a fairly serious movement for courts to identify these sorts of rights and then stop laws that violate those rights. Okay. Now we get to the New Deal. And these cases became extremely unpopular. The New Deal court began to uphold laws that violated the liberty of contract. And they said, it's can get democratic process. If the legislature wants to restrict the price of a loaf of bread, or they want to restrict the price of insurance contracts, or if they want to restrict the minimum wage for women, they can do that. And this doctrine led us to West Coast Hotel v. Parrish, where the court said, no more. We are now out of the business of strictly scrutinizing laws that violate unenumerated rights. We're not in this business anymore. And Caroline Products changed the way that courts would review these sorts of laws, right? We will no longer strictly scrutinize laws that violate unenumerated rights. The court did not deny that there is a right of contract. They didn't quite go that far. They simply said because this right's not written down, the courts have to be more restrained. And they can't go around strictly scrutinizing and closely reviewing laws. Generally, they'll defer. Okay. That was West Coast Hotel. Several years later, we get to our favorite footnote and our favorite decision, which was United States against Caroline Products. The bulk of Caroline Products was fairly mundane. The court basically said that if a law violates the liberty of contract, the courts will allow the plaintiff to give some evidence to explain why a law is unreasonable, but generally they'll defer. Then we have footnote 4, right? It was a very, very important footnote. It did lots of things in a very short span, but it created these 3 exceptions to the rule, where generally courts will defer to the democratic process unless one of these 3 things happens. If a law violates a specific provision of the Constitution, such as a provision of the Bill of Rights, that would be a strict difference. This is obvious, right? If a law violates the First Amendment, the court's going to go after it. That much is fairly straightforward. The second category has to do with political processes. That if the government tries to stack the deck, which laws are enacted or repealed, those laws are also suspect. Not deference. When I say scrutiny is a homicide. There's a third criteria of footnote 4, which is if laws target certain minorities who are discreet and insular, who can't protect themselves. Those laws also will be reviewed carefully and not given deference. Footnote 4 of Caroline Products tried to say, as a general matter, courts are not going to intervene in the political process unless there's some really egregious circumstances, some really bad circumstances. And those are the 3 exceptions. What happens to the liberty of contract after Caroline Products? Well, guess what? Liberty of contract is not enumerated. Therefore, it doesn't receive the sort of heightened scrutiny that the other rights would in the Bill of Rights. Caroline Products basically cut short the Lochner era cases and no more. We're not going to do it. That compromise didn't last very long. Throughout the 1950s and 1960s, the court began to experiment with the concept of substantive due process. One case we studied was Bowling v. Sharp. Right, this was a segregation case from D.C. The Fifth Amendment, which controls Congress, does not have an equal protection clause. The court says it doesn't matter that the word liberty in the due process clause embraces the concept of equal protection. This wasn't quite Lochnerism, but it was giving a little bit more juice to the concept of the due process clause. And there were other cases decided in the same period concerning rights of privacy in the criminal law context. If you've taken CrimPro yet, or if you will, there are lots of cases about right of privacy in the criminal context. And slowly the court began to recognize that Caroline Products was very constricting, right? It was like a pair of handcuffs. The court tried to tie itself to the mast, so to speak, to use the mythology reference. And they suddenly realized that, well, we don't like these handcuffs very much. We want to free ourselves a little bit. Griswold was an effort to sort of crack open those handcuffs a bit, to release some of the pressure that was placed by the New Deal court. And they did so in a case that did not involve an economic right, but involved a personal right or a personal liberty. Specifically, the right of marital privacy. This case wasn't about a right to privacy in the abstract. It involved specifically a bond between a husband and wife, and whether the state could regulate what goes on inside that bond. The facts here were actually quite narrow. This was not about an unmarried person seeking contraception. It was about a married couple. There was a case some years later about unmarried people, and the court will get to that eventually. But at least here, the right was very closely tied to marriage. The vote in Griswold was very fractured. There were lots of opinions, and when there are lots of opinions that the justices don't really agree on it, they don't really agree with each other. I think that was a reflection of the fact that they didn't know what to do in this post-New Deal world. How would the court begin to break free from Caroline Products without ushering back in the return of Lochnerism? And you can see that fear of Lochner. I read a paper recently called Lochner phobia, which I love the phrase. There's this abject fear of Lochner that just sort of like haunts people. It's this pathology, it really is. But they have this fear of Lochner, this Lochner phobia, that anything they do here will just bring back, the progressive era court, which sets aside these economic regulations. They were afraid of that, did not want to do that. Anyway, to understand Griswold, I think you have to keep that history in mind. This case was designed to give the courts a license to scrutinize these sorts of personal liberty laws without resurrecting the scrutiny that existed in Lochner and in Adkins and the other cases. Okay, questions on that introduction? It's a little monologue. All right, Lindsay, you're up. You want to give me the facts, please, in Griswold?
Connecticut had a law that made it illegal for doctors to counsel or assist married couples.
What does it mean, counsel or assist? Just let's just
prescribe or I guess recommend what they use.
Okay, so this law didn't only apply to doctors, right? Because it applied also to people who counsel them. So basically, if I recommend to someone, you should really look into this sort of contraception, that would be running afoul of the law. Now, generally, Lindsay, as a general matter, can the state regulate what drugs are prescribed? I know that's an obvious question, but can I just, if I'm a doctor, can I just start prescribing like cocaine for a headache or something?
Yes,
I mean, back in the day, cocaine was actually an analgesic. They would prescribe for toothache and the like. Right. So I mean, there's a weird aspect of this case. Is the state really saying that the Constitution limits the sort of things that people can prescribe as doctors? Is that, I know you didn't think of it that way, but is that what's at issue here? Can this, think of the eye doctors, right? You have to be an eye doctor to make the glasses. Can't the state say that only licensed medical professionals can issue these contraceptives, and we think these shouldn't be licensed, they're not safe, they're not
You're like, is that what they were trying?
Why couldn't the state do that?
Like, why does the court?
No, I'm asking, why couldn't the state license the sorts of contraceptives? These are pharmaceuticals that are given out. Why can't they do that? Estelle Griswold was not a doctor, right? Mm-hmm. Buxton, the other guy, was. Mm-hmm. Griswold was not a doctor. Why the hell can the state not say to a non-doctor, you can't prescribe pharmaceuticals?
They're not prescribing?
I can't go to someone and say, you know what, I'm not a doctor, but here's what medicine you should take. I think I'd go to jail. I can't. Same with the law, right? If you're not an attorney, you can't go and give legal advice. It's called the unauthorized practice of law. So here is unauthorized practice of medicine. Yeah.
So I read it as it says device or article. So I thought that included condoms.
Did.
Were they available for purchase in Connecticut?
I think you need a prescription. I don't think it goes over the counter. Oh, today I think they are, but I don't know that Connecticut allowed it over the counter. I think it was prohibited.
Okay.
But Chelsea, let me ask you this question. Does a doctor have a constitutional right to prescribe a drug?
For the health, if they need it.
Oh, this is a good question. Let's say you're terminal, right? You have a terminal illness, and there's an experimental drug, and the FDA says we're not releasing it yet. Do you have a constitutional right to access that drug? You're going to die anyway, and you want to try an experimental drug. Is the government required to give you an experimental treatment? I know the answer, but what do you think?
I don't know. No.
The short answer is no. There was a case called Abigail Alliance from almost 10 years ago, where there was a terminally ill patients who had basically, they had life sentences of a fixed period, and they sued arguing that I'm going to die anyway, right? If I take an unhealthy drug, so what? And the government said, we're not giving these experimentals. They're not going through the trials yet. So unless you qualify for a trial, you're not going to get it. And the courts basically said that you don't have a constitutional right, a due process right to access these drugs. But that's neither here nor there. The question I pose to you, Chelsea, is this. Does a doctor have a right to prescribe a drug?
Yes.
Constitutional right? But why? It's a regulated profession, highly regulated. Does a constitution protect the right of a doctor to give a drug? Condom, foam, diaphragm, whatever it happens to be? Tyler, who should have been the correct plaintiffs in this case? Who would have been the ideal plaintiffs in this case? Not Miss Griswold. I don't mean to make fun of her, but I don't know if she was of childbearing age at this point, right?
Married couples suffered.
Yeah. Married couples. Why on earth, Tyler, is the plaintiff doctor, actually plaintiff is the wrong word. Why are the parties in this case, Dr. Buxton and Ms. Griswold, why the hell are they the parties?
They wanted the result. They wanted to test the test case.
But wouldn't the court just say, maybe married couples have this right of privacy, but you have no right to prescribe it to them? Wouldn't that be a result that would make sense? Come back when you actually have a married couple prosecuted for violating this law. Why is that not the remedy? Why don't they just dismiss the case? Let come back with an actual married couple. Who are Griswold and Buxton, who I don't think were married? Right? Who the hell are Griswold and Buxton to assert the right of married couples? Who are they? Why did they have to do this?
Charge, right? It's
Oh,
a criminal case.
right. They were, but the crime for them was distributing it,
Accessory.
not actually using it in the bedroom. Yeah, Chelsea.
But how would they catch the people using
Oh. How would they catch people actually using it?
They would have to go into their homes. So,
This is the setup for Lawrence v. Texas you'll read about next week, I think. You actually had cops burst in and they claimed they saw two guys engaging in sexual activity. So it's going to be the rare case where you can actually catch people using these products. But that simply avoids the question, right? This law is basically impossible to enforce, right? You're not going to actually ever have enforcement against married couples. Fine. But that doesn't answer my question. Why does a doctor have a right to assert marital privacy as a defense? Lindsay?
Is this like a Pierce versus Society of Sisters? Where you assert the right to
Very
privacy being
good.
violated?
Very good. In fact, Pierce was cited in this case for that exact idea. There's a fairly long-standing doctrine that it's kind of weird that one party can assert the constitutional right of another party. That if you're the school, you can assert the constitutional right of your students. And if you're a teacher, you can assert the constitutional rights of the parents of your children. Right? It's almost backwards. Or if you are the honk and holler, my favorite, right? If you're the honk and holler grocery store, you can assert the right of men who are unable to buy beer at the age of 18. It's a concept called third-party standing, and it's a little fuzzy. This is not a class in jurisdiction, but I just want you to be aware of this point, right? How can Planned Parenthood, which performs the abortions, assert the right of the women seeking abortions? Right? How can the provider of the service assert the right that the users of the service have? It's not black and white, but the courts generally agree that third parties can assert these rights. Shocker, shocker, this doctrine was largely developed during this 60s and 70s period where you had these abortion cases where you weren't going to have a husband and wife who were arrested for using condoms. Just that was not going to happen. So they needed a test case. I think Tyler said that a minute ago. And the test case was Griswold and Buxton deliberately sought to get arrested. Right? They wanted to get arrested. You know, whenever you see a case where there are photographers at the perp walk, right, where the photographers are present as they're getting booked, they're there deliberately. They want to get arrested. Now, couldn't Connecticut just repeal this law? Indeed, as this litigation was proceeding, the Connecticut legislature took steps to repeal the law, right? Wouldn't it be better for society if instead of having courts set aside laws, you have the legislature get rid of these old laws? Wouldn't that be better? Well, sure, but that wouldn't set a nationwide precedent that would apply in other states where the state may not want to, right? They wanted a Supreme Court decision, and that's what they got. Now, I would prefer that the legislature just changes the law, but you know, what do I know? It's a quaint idea. But here we go. Yeah, Tyler.
So if this has been the case all along and I haven't noticed, I apologize. Is there something to all of this reference to each other as brother within this particular case?
Yeah. That was a common phrase where they would refer to each other as brother. And in fact, there was a famous book by the court called The Brethren, published in the late 70s, about the members of the court. That practice stopped shortly before Sandra Day O'Connor joined the bench, because she would not be a brother, she would be a sister, I guess, I don't know. But that was a very common phrase, my brother this, my brother black. It was meant as like a show of respect that they're all brothers together. It is kind of weird. They all hated each other too, which is the damnedest thing, right? I mean, they really, some of the justices here, Justice Black, Justice Douglas, I think Frankfurter's already gone at this point, but they all hated each other. They did not get along well.
And it was just this group that referred to each other as brother?
No, this went on for a few decades.
Okay.
But I think, I don't know if you've seen other opinions. You might, maybe in Craig v. Boren, you saw brother? I can't remember.
This one just seemed excessive.
Yeah, also because there were so many different concurring opinions.
Right.
Now they'll just say justice this and justice that, or the chief justice. They don't do the brother stuff or the sister. It's a little weird. I don't know. Okay. Anyway, Griswold and Buxton were arrested for prescribing and counseling a couple on how to use the contraception. They were fined $100. The court finds that they have standing to raise the rights of these third parties. Okay. At the beginning of the opinion, Justice Douglas goes out of his way to say, "We're not doing Lochner here. Don't worry. This is not Lochner. We're going to stick with West Coast Hotel v. Parish, right? We are not a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, and social conditions. However, this law operates directly on an intimate relation of husband and wife and the physician's role in one aspect of that relation." All right. So this argument raises the obvious question: why are laws affecting intimate relations different than laws affecting economic problems? Who's next? Chelsea, I think. Why are they different? Why is there a difference between economic regulations and intimate relations? What's the difference?
That's a good question.
Thank you.
I'm sorry, I don't know.
Well, you're not bleeding hard enough, right? Why might there be a difference between how many hours you can work and then what you can do in a bedroom with your spouse? Why might those be different concepts?
One's more private.
Private. Okay, I think now we're on the right track. Yeah, what the court is sketching here is that there's this right of privacy, And we'll get to the specific penumbra stuff in a moment, right? But the concept of a right of privacy is different than the sort of industrial relations that happen in public, right? What wage you're being paid, how many hours you're working, those are all public affairs, and reasonable minds can disagree, and there should be deference. But what Douglas is getting at is in intimate, personal matters, there's some privacy to it that the legislature has no business knowing about. Now, how does he know this distinction exists? It's not real, right? It's artificial. It's completely artificial. It was more or less a reaction to the, sexual cultural revolution in the 60s, and a recognition that, we have to get involved here. We can't let these states ban contraception, because they can ban contraception, they can then ban abortion. Right? This sort of decision was basically just a prelude to a right to abortion. That was what the were leading towards. There was no mystery about this, right? In fact, the lawyers for Planned Parenthood argued vigorously in this case, no, this is only about married couples, only contraception, and no one believed it for a second. So they draw this distinction, right, between economic and intimate liberties. To this day, that distinction exists. Even the most conservative members of the court, Clarence Thomas and now Justice Gorsuch, for example, referred to the Lochner cases as discredited, that they were wrong. This is a Lochner phobia we see. But the modern day hostility towards Lochner on the right is a direct backlash to Lochner. I'm sorry. The modern hostility towards Lochner on the right is a backlash to Griswold. Because if Lochner's wrong, then Griswold has to be wrong, they think. Aha. But if Lochner's right, then Griswold has to be right. Maybe, maybe not. Maybe there's actually a originalist argument in favor of liberty of contract, but there's not one in favor of abortion, for example. I think you can have both positions. Lochner wasn't invented of whole cloth. You had the Civil Rights Act, you had Slaughterhouse, you had a fairly long history of liberty of contract being something that existed, not so for a right to contraception. The entire idea of contraception was fairly, novel is the wrong word, but the technology didn't exist the way it did in the 60s. I don't think latex even existed at this point. I used to have pictures of some of the contraceptive commercials from the 60s. There's a lot of different types of foam that were basically spermicides. I have no idea how effective they were. Would not take that one to the bank. And they were called rubbers because they actually made of rubber. They were actually rubber. Anyway, you're talking about fertility last night, talking about fertility again tonight. Okay. So any question in the first part of Caroline Products that it sort of splits off footnote 4 a little bit to talk about intimate relations. Okay. The court then tries to find support for this fracture. And it looks at cases decided during the Lochner era, in particular Meyer against Nebraska and Pierce v. Society of Sisters. Now, we studied that these were Lochner era cases. They were rights of businesses to teach and the rights of teachers to educate. These cases were not about the First Amendment, but here the court suggested they were. They said, aha, Meyer was about discrimination against, Germanic people who spoke German, and Pierce was about discrimination against people who are Catholic. You have nationality discrimination, you have religious discrimination. That's a First Amendment issue, which is just emphatically false. These cases concern both economic and personal liberties. Neither case involved the First Amendment with good reason. At the time, the First Amendment had not been incorporated. That is, the First Amendment did not limit state authority. The court would not hold that the First Amendment limits state authority until some years later. So these were not First Amendment cases, but Justice Douglas, to graft this right of intimacy, he reaches for precedents involving substantive due process. Aha, we have precedent. Okay, so any questions on that so far? Then things start getting a little bit weird. Did I give you the video for Griswold yet?
No, sir.
Oh boy, I'll show it to you here. I'm sorry. It's this one's taking. I don't know why. I thought we were done with this one. Oh, there were some errors in it. I see. I'll play a clip from it, so you understand the penumbra concept. This is one of the. This video I'm very proud of, actually. Where is it? Here we go.
Clause. In neither case did the court rely on the First Amendment. Third, Justice Douglas read the court's precedents to protect a right of privacy. He wrote, quote, specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Astronomy guide. An
Pay
emanation
attention.
refers to a ray of light. During a lunar eclipse, the umbra refers to the darkest part of the shadow formed when the Earth orbits between the sun and the moon. The penumbra refers to the lighter part of the shadow, where some of the emanations from the sun are visible.
Okay, everyone get that? Really, you're smarter than I was. This took us forever to figure out how to explain this in a cogent fashion. We made this animation ourselves. Pretty nice, right? Yeah, this took a while. So the general idea is, did you guys take astronomy in college? Okay, well, I did many years ago, so I'll try my best. But the sun makes light, and it casts light on the Earth. And that's why we have night and day, right? The Earth rotates, and as the light goes here, this is day, that's night. What happens when the moon orbits around the Earth, right? And it falls inside the shadow, right? That's when you have a lunar eclipse. You can no longer see the moon. And the dark part of the shadow is called the umbra, right? But then a little bit of light sort of escapes, so the shadow's a little bit lighter. These are called the penumbras, right? So the emanations from the penumbras is the light from the sun that sort of reflects off and goes to these sorts of corners. Okay, everyone with me? I'll play another few seconds.
If you don't understand this analysis, you're not alone. To this day, critics of an unenumerated right to privacy widely deride Justice Douglas's use of emanations and penumbras.
Yeah, okay, so far so good, right? Now, here comes the fun part. The emanations and penumbra stuff is basically this sort of bizarre astronomy concept, but there's a specific reason why he's doing it.
Justice Douglas continued, various guarantees in the Bill of Rights, he said, including the First, Third, Fourth, Fifth, and Ninth Amendments, create zones of privacy.
Okay, by the way, this is the graphic of the Bill of Rights. And you may not be able to see this, but if you look closely, it says Article the 3rd, I'm sorry, Article the 2nd, Article the 3rd, see that? Article the 4th, Article the 5th, you see that? Why is number 1, the First Amendment, next to Article the 3rd? You know. You remember.
First two weren't ratified.
Bingo. Yeah, it's a little Easter egg in the video, right? The first 2 amendments were never ratified. Actually, one of them was ratified in 1990 something, right? The 27th Amendment.
Is that the equal?
Yeah, that's the pay for members of Congress. The 27th Amendment was actually proposed in 1791 and was ratified in 1992. Thank you. Right? Anyway, that's why Article the 3rd is the First Amendment, Article the 5th is the Third Amendment, and Article the 11th is the Ninth Amendment. It's a little Easter egg which no one will ever notice, but we put a lot of care into these graphics. Douglas is trying to explain this concept that there are certain provisions in the Bill of Rights that create these zones of privacy. So he picks off at random the first, not random, but he picks off the first, God, not the second, right? The First, Third, Fourth, Fifth, and Ninth Amendments.
Study.
Okay, it's enough for video. Yeah, this is a good one. I might play some clips in a minute. Just as Black and others. But this is how we have to edit them. I basically go minute by minute and find various edits and things I have to jump change. It's insanely time consuming. When did I meet? 3 days ago. Okay, that's why it's not done yet. Okay, now why did Justice Douglas look to the First, Third, Fifth, and Ninth Amendments? Well, the First Amendment has a right of association, right? That looks like a privacy, right? You associate with people privately. The Third Amendment, you can't quarter troops in the home during times of peace. Aha, privacy. The Fourth Amendment, the right of the people to be secure in their persons, papers, and effects against searches. Aha, privacy. Fifth Amendment, you don't have to incriminate yourself. Aha, privacy. The Ninth Amendment, which says the enumeration, the constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Privacy. So all these things reflect instances where there's privacy. So of course that means the Constitution protects the right of privacy. But wait a minute. We're talking about the 14th Amendment here, not the Bill of Rights. What does this have to do with it? Right? Why is he bringing the Bill of Rights into this analysis? And the answer, at least Randy and I think, is because of Caroline products. The first exception to Caroline products suggested that heightened scrutiny was warranted for laws that violate express prohibitions of the Bill of Rights, enumerated rights. So what's he saying? The right of privacy is an express prohibition of the Bill of Rights, right? It's a zone of privacy that emanates from the Bill of Rights. I mean, you see this, the insanity of this, right? That footnote 4 says if it's expressly listed in the Bill of Rights, you give it heightened scrutiny. So Douglas says, aha, well, it's expressly enumerated, or maybe emanated. It's expressly emanated from the Bill of Rights. It's like this sort of vibrating emanation. And then you see that zone of privacy that comes out of it. Douglas was trying to shoehorn. He was trying to shove this newfangled right of privacy into the provisions of the Bill of Rights to keep it within footnote 4. Because he was afraid that once we get rid of footnote 4, then the entirety of the New Deal settlement is done. We go back to Lochner, and he couldn't bear that. All right, so that was the sort of gist. He was trying to pigeonhole or shoehorn this right of privacy within the Bill of Rights. Did anyone see the eclipse 2 years ago, 2017? I actually, a funny story, I went to Nebraska for the day because that was a place within the totality where there's a full solar eclipse. Unfortunately, it was freaking cloudy. So I traveled to the 2 hours from Lincoln, Nebraska. Really not much going on there. Beatrice, Nebraska. Nice town. We hung out in the Walmart parking lot to look at the eclipse, and it was cloudy, which was very sad. But I'll tell you that during the eclipse, I did not see any zones of privacy emanating from the sun. There were none. So that eclipse was not a good experiment for this right of privacy. I was waiting for it, but it just never popped out. All right. And by the way, this is what passed for constitutional law in the 60s. Even the most zealous supporters of rights of privacy and rights of abortion don't defend this decision. It's not law, and it doesn't even try to be. It's this sort of, let's just make crap up because we have the votes. Even today, the progressives in this court would never cite this sort of reasoning. They would develop, and I'll give you an example, right? For example, restrictions on a right to abortion are laws that only burden women, so you form sex discrimination, right? At least that makes sense. Maybe it's right, maybe it's wrong, but it's not penumbras. It's not emanations, right? It's not this sort of whatever that was in Griswold. So I encourage you to study Douglas' opinions carefully, but don't think that this is an accurate statement of how law developed. If anything, the Harlan opinion, I think, I'm closer to where the law is today. We'll get to the concurrences in a few minutes. But does everyone at least get the this aspect of Douglas? Okay. All right, so Douglas writes that This case involves a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. And the law achieves its goal by having a maximum destructive impact upon that relationship. Okay. Such a law cannot stand in light of the familiar principle that a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broad and thereby invade the area of protected freedoms. It's gibberish. But what he's saying is this law goes too far, that you can't prohibit this aspect of a private marriage. Right? We wouldn't allow the police to search, oh God, Douglas, the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives. Dude was married like 4 times. He divorced his wife several times, married his new secretary, did this a couple times. He was a lech. I mean, the reason why he actually wanted to run for president, but he couldn't because he was divorced and was considered to be too scandalous. To even read him talk about the sacred precincts of marital bedrooms is just sickening. Right? This guy would leave his wife for his new secretary a couple times, and then when she got older, he would find a new secretary. He was not well liked, Justice Douglas. The very idea is repulsive to notions of privacy. But think about it, right? He's saying you can't search a marital bedroom. Is an abortion clinic private in the same sense? Is it private? No, it's a public facility. There are doctors there. There are nurses there. There's a waiting room, right? You're not alone with just 2 people. In fact, it's 1 person. So this entire idea of the sanctity of marriage quickly gets jettisoned. There was a case a couple years later called Eisenstadt versus Baird, B-A-I-R-D, where the court held that you cannot limit a right of contraception to married people, that unmarried women also have to have a right of contraception because it's an equal protection issue. So all this bullshit, about the sanctity of marriage, it didn't even make it past 1971. It lasts 5 or 6 years. None of this was necessary. It was window dressing. It wasn't real. Yeah.
So, do we read this case? Why do we read this case? Is it because of the transition?
Bingo. Yeah, bingo. It shifted the court's approach to due process in a momentous way. And
by shifting, does it mean that now they're recognizing privacy as an enumerated right that gets...
Look, you read Roe. Roe's our next case. We'll do it in second half of class. But does Roe mention penumbras? And no. They just sort of move past it. In fact, Roe is completely ambivalent about the basis of the right. Maybe it's the 14th Amendment. Maybe it's the 9th Amendment. We don't really care, right? Roe is completely and utterly ambivalent about the basis of the right. Here, they at least tried to ground it in footnote 4. By the time you get to Roe, they gave up. They said it doesn't really matter. We think it's important, so it's a right. When you get to Casey, it becomes more about the 14th Amendment and liberty, right? They try to ground the 14th Amendment. But in Roe, the actual basis of the right was irrelevant. They didn't care about footnote 4 of Caroline Products by the time we get to 1973 for Roe. And that's it. I mean, that's the opinion. It's a very strange opinion. I mean, every year I read, I'm like, wow, what the hell did I just read? It's like I went on an acid trip or something, right? It's very strange.
Within the zone.
Okay, so there were 3 main concurring opinions. Justice White, Justice Harlan II, and Justice Goldberg. Harlan was actually the grandson of John Marshall Harlan. This was John Marshall Harlan II. You read John Marshall Harlan I. He wrote the Plessy dissent. He wrote the Civil Rights dissent. He wrote the Lochner dissent. Let's just say the grandfather outshined the grandson. Harlan I was one of the greatest justices of all time. Harlan II was, important for his time, but doesn't rise to his grandfather's stature. But he was a very influential justice because he was considered more of a moderate, a little bit of conservative in that sense. But let's walk through them one at a time. All right, we have Justice Arthur Goldberg, who at that time I think was the only Jewish justice. He had filled the I think it was in the Frankfurter seat basically. He basically says, well, you know, I agree with the majority, but here's a completely different way of looking at it, right? It's like, okay, whatever this penumbra crap, I don't really care. And he looks at Ninth Amendment, right? And the Ninth Amendment is a provision that, you know, we don't really study very much. Randy, by the way, is one of the nation's experts in Ninth Amendment, so I don't do justice, so I defer to him on this topic. But the Ninth Amendment provides, I'll read it, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Okay, what does this mean? Well, look where it belongs in the Bill of Rights. The first 8 amendments list various rights that people have. They have rights of speech, rights of exercise, right to bear arms, etc. Right? The first 8 amendments are all limitations on government power to protect certain freedoms. The Ninth Amendment and the 10th Amendment are a little bit different. The 10th Amendment describes the allocation of powers between the federal government, the state governments, and the people. Right? If a power doesn't belong to the state government, if a power doesn't belong to the feds, it then belongs to the states. The Ninth Amendment's a little bit different. It doesn't discuss the allocation of power between the states and the federal government. It describes the allocation of rights. And what it suggests is that you're going to have some rights listed here, but there are other rights that are not listed. And the mere fact that a right is not listed, let me phrase without the negative. I always phrase it poorly. If a right is not listed, it still can be protected, right? You should not diminish unenumerated rights. You should not disparage other rights retained by the people, right? In other words, our Constitution does more than protect the rights in the first 8 amendments. It protects other rights, and those rights retained by the people shall not be disparaged. Okay, that sounds awesome, right? But this raises an obvious question. What are those rights, right? If a right is not written down, how are we supposed to know what it is? And this is the entire debate about substantive due process, right? How are courts to identify rights that are unenumerated? How are they to know what they are? Is the right of contract enumerated? Maybe it is, maybe it's not. Is the right to abortion or contraception enumerated? Maybe it is, maybe it's not. How do we know what these rights are? Second question is this a provision of the Constitution that the courts are involved with, right? Is it the legislature's job to protect these rights? Or should the courts intervene to set aside laws that violate these rights, that the courts find them, right? In other words, who actually polices the Ninth Amendment? This is one of Randy's big things. He thinks the courts do it. Okay, everyone with me so far? But there's a problem with Goldberg's opinion, right? The Ninth Amendment appears in the Bill of Rights. And the Ninth Amendment concerns the relationship between the federal government and rights. It does not concern the relationship between the states and rights. In other words, the Ninth Amendment says nothing at all about what rights Connecticut must protect. You don't incorporate the Ninth Amendment. It has not been an incorporated right. In other words, the Ninth Amendment does not provide the basis for a ruling in favor of Griswold. All that Justice Goldberg says, and it's very narrow, is that the Ninth Amendment is proof that we have unenumerated rights. You don't need to go through emanations and penumbras. The Ninth Amendment tells us that the framers were comfortable in protecting unenumerated rights, and then the courts can decide what those rights are. Right? Everyone understand that? But here's the key. Doesn't that conflict with Caroline Products footnote 4? Right? Doesn't Caroline Products say that if a right is not enumerated, we give it the presumption of constitutionality? Right? If a right is not enumerated, government can violate, no big deal. Courts won't intervene. And if that's the case, isn't footnote 4 inconsistent with the Ninth Amendment? Right? Doesn't footnote 4 expressly disparage the rights retained by the people? So Goldberg does what Douglas will not. Goldberg, at least quietly, pushes away footnote 4 of Caroline Products. He's saying, we're not going to treat unenumerated rights as second-class rights. We will give them their full due. And the courts will decide what those rights are. Lindsay? I think you said an aha moment.
I don't know if I did or not, or if my brain just broke.
I think I saw you in an aha moment. I'll take it.
So, the Bill of Rights is the first 10 amendments, which includes the Ninth Amendment. So what happens when you enumerate unenumerated rights?
Well, yeah. That's why if you actually look at the book very carefully, we always say the first 8 amendments. We use that phrase over and over again. That's quite deliberate. I might slip and say Bill of Rights, but I really shouldn't. I say the first 8 amendments because the 9th and the 10th amendments are basically federalism provisions. They limit federal power. They're not rights that could be enumerated by the Due Process Clause. So I don't know that you could even have an incorporation of the 9th Amendment. But again, look at the Roe case. In the district court that cited, the district court found that the 9th Amendment protects the right to abortion for the states. Who knew?
But in footnote 4, it says the Bill of Rights.
Oh, it does. It's sloppy.
So
yeah, it does that.
Did they intend for it just to be the first 8, or?
I think it was a. Well, let me give you 2 answers. First, I think it was sloppy. I don't think they were being precise. Second, the phrase Bill of Rights doesn't only mean the first 10 amendments. Historically, the phrase Bill of Rights meant certain and really important protections. Today, we use it to mean exclusively the 10 amendments. That's not how it's always understood. In fact, Franklin Roosevelt was perhaps most famous for using the phrase Bill of Rights to refer to the first 10 amendments. But yeah, there's a huge tension between Caroline Products footnote 4 and the 9th Amendment. I'll give you another example. We won't have time, but there are cases on the Second Amendment. The Second Amendment is enumerated, and the courts, Justice Breyer actually wrote an opinion that because the right to bear arms doesn't affect discrete and minorities, we don't have to give it heightened protection. And he doesn't recognize that it's enumerated. He forgets the first one. He goes right to the third paragraph. And that's why I always jump on Justice Breyer whenever he makes that point. All right, so if I can get Goldberg, right? Goldberg's willing to break away from footnote 4. And look who joins him, Warren and Brennan, both justices who joined the court after the New Deal. Right, they came on board in the 50s. And they were willing to push away from that New Deal settlement. Okay. Justice Goldberg concludes, the right to privacy is fundamental and basic, a personal right retained by the people within the meaning of the 9th Amendment, and they can't abridge this right protected by the 14th Amendment. Which one is it? The 9th Amendment, the 14th Amendment, who really cares? Right? It didn't matter. Right? What the court was getting at here is, we're going to find what these rights are, and the basis in text is not very important. What's important is protecting this freedom. Everyone with me? Any questions? All right, the second concurrence from some Justice Harlan Harlan II, yeah. And Harlan, again, was somewhat of a conservative. He doesn't like this penumbra stuff. That wasn't his business. Instead, he would be willing to say, we have the word liberty in the Bill of Rights. Let's just be candid that what we're doing here is protecting liberty, the same way Lochner was, perhaps. And what does the word liberty mean? He says it refers to certain values. And to violate these values would be bad. Harlan uses this phrase, implicit in the concept of ordered liberty, which is a very important phrase. All right? I can't remember who's next. Who's next?
Me.
Tyler, what does this mean? Implicit in the concept of ordered liberty, that some right is so fundamental that it's implicit in the concept of ordered liberty. What on earth does that mean?
I took it to mean that in and of itself was enumeration enough. And looking at the way that he mentioned in the text that he discussed it at length in his dissent in a previous case, there's a long reference to, hold on, let me find the right word. Justiciability.
Justiciability, okay.
And the way that it permits certain non-enumerated, ability to decide within the individual, and not for the courts, and not in the business of the judiciary to intervene. To do so would be the equivalent of judicial activism. Therefore, looking at liberty alone as enumerated was enough.
But what's ordered liberty mean? What does it mean to be implicit in the concept of ordered liberty?
It's understood. It's inherent,
What's inherent mean?
embedded in the fundamental concept of it.
Yeah, you're describing it with other buzzwords, right? Inherent, fundamental. You're not doing it wrong. I think you're answering it in a responsible way, but what the hell does this mean? Lindsay, what does implicit in the concept of ordered liberty? Use it, describe it in a way that your family who's not lawyers would understand.
When you think about the concept of liberty, if you were to ask someone what it means, these would be ideas that would fall into almost everyone's concept of it.
Okay, I think we're getting there, right? So specifically ordered liberty. What does ordered add to the situation?
Not anarchy.
Not chaotic, right? So this is not some sort of like libertarian utopia. You're not like in an Ayn Rand novel where like you can do whatever the hell you want, right? So there's some order to society. But within society, there's certain really important values that most people would agree exist. And these are the values that are implicit in this concept of ordered liberty. And a law that runs afoul of these values violates the 14th Amendment. That sounds great, right? Chelsea, how are judges to decide what these values are? Is there a poll they can look to, right? Is there a survey that justices can send out? Add a question to the census. Is this a value implicit in the concept of ordered liberty? How is a judge to decide what these values are?
Based on their own feelings.
And what does that remind you of? What case? What does that bring us back to?
Oh, I have it.
It's a biggie. They really hate this case.
They hate it. Is Lochner?
Bingo. Doesn't this bring us back to Lochner? That the court can simply assess what values are very important that society needs. Remember Justice Sutherland or McReynolds had this list of marriage and bringing up your children, etc. How do you know that? Well, that was his conception of ordered liberty. And what Harlan's saying is, we will decide if a law runs afoul of this ordered liberty. Again, that's why Justice Douglas didn't go down this road. His penumbra bullshit avoided the need to discuss the 14th Amendment. He's like, look, we're not doing Lochner. But every other opinion went right into Lochner. Right into it. Now, perhaps you might say, what's the best reflection of ordered liberty? What law society actually enacted. In other words, if you want to know what society thinks the laws should be, shouldn't you look at the laws society enacts? That if Connecticut has this law about contraception and they want this on the books. Shouldn't that be the reflection of what society should allow? If society wants to regulate this aspect of morality and prevent married couples from using contraception, why shouldn't they be able to? In other words, it expressly allows the judge to interject his own views of what society should allow over what society in fact allowed. Right? This approach lets a judge say, no, society wanted X, but I think they really want Y. It's like, no means yes, right? It's like, no, you didn't really mean that, right? You didn't really want this law. Here's what you really wanted. Right? Who's a judge to say nationwide what the values are for an entire country when each state has slightly different laws that their own people and their representatives want? This is an expressly anti-democratic principle by which courts identify rights. Now, I think there's some scope where this could work, right? Imagine that there's some right that was long protected, and then suddenly people start banning it. They say, no, we don't want this right anymore. Maybe a judge will say, you are now eliminating this old, deeply rooted right that's long existed, right? You are taking away something that people have long valued. I think here the Harlan formula has some value. But the right they're asserting here is not deeply rooted in history and tradition. It's novel. It's new. It didn't exist 5 minutes ago. They just made it up. So Harlan's concurrence forms the basis for one strand of modern substantive due process theory. There's a case called Washington v. Glcksburg, Glucksberg. This case involved whether the 14th Amendment protects a right to assisted suicide, right? The right of a doctor to help someone kill themselves if they're terminally ill, for example. The court found that such a right did not exist, but they put down this test, and they said the court will only protect liberty if that right is deeply rooted in history and tradition, right? If the right is deeply rooted in history and tradition, that there's a tradition that, in fact, ordered societies have protected this right, and they've changed course, and they started not protecting it, right? If there's an old liberty that was protected, and now it's changed, that they're not protecting it anymore, the courts can intervene. But if this is a newfangled right, the courts will not intervene. That's Glcksburg, the so-called Glcksburg test. That's one test, but not the only test. Justice Kennedy rejected that in a number of decisions. Justice Kennedy said, no, we look to modern liberty, right? We look to developing norms. How have people treated gays and lesbians in the last few decades? That's more important than in the other part of recorded history since time immemorial, right? It doesn't matter if gay marriage didn't exist till the 1990s, right? That doesn't matter. What matters is what's recent and how people write books and articles and they discuss things. You'll read Obergefell last day of class. The Obergefell sort of test is in tension with the Harlan Glcksburg test. They're very much in tension. Obergefell did not overrule Glcksburg, but it put it on ice. I think the court will revive it now that Kennedy's on vacation, permanent vacation, as they say. But the roots of the Glcksburg test began with Harlan. Now, Harlan doesn't have this sort of deeply rooted element. He's okay with saying a modern right can be a right that's implicit in the concept of ordered liberty, right? He can look to modern rights like contraception, privacy, even if there's no history of that right. So the Harlan test was ultimately modified, but it did have a lot of significance. Okay, does that make sense? Funny, I forgot. This is really familiar because I was randomly in DC for something, and my old professor David Bernstein was teaching ConLaw. And I was at Mesa. Like, hey, do you want me to teach your class? So I was like, yeah, sure. What are you teaching at Griswold? So I actually taught this case cold without any notes. Now that's why it's so fresh in my memory. But yeah, it was weird because I was teaching in the same room where I took ConLaw years ago, except I was on the other side. Bastard gave me an A-, whatever. It's okay. All right, but everyone okay with the Harlan opinion?
Yeah, this is kind of crazy.
Go for it.
So he referenced that Pope case
Povey Ullman, yeah.
Yeah, and that really, I was wondering, he wrote a very long dissent.
He did, yeah.
In that one, and it talks about this Dr. Buxton the Poe case was his first attempt to do the same thing.
They tried to get a test case, they couldn't.
With a married couple, and they said, there's no injury, you guys weren't charged.
That's when we tried to get arrested, this one.
Yeah, and that's as accessories. So that's pretty. And Dr. Buxton, was he the one that was over the OBGYN over Yale?
Yes, sir.
I wonder if with only one prosecution on the books at the time of Poe, and then this one, what was the intent for somebody in academia to really have this much of a vested interest in a Connecticut law?
He wanted to set a nationwide precedent. They wanted to set a nationwide precedent. Now, there's a doctrine called desuetude. You ever hear that phrase? Let me write it. It's a weird word, and I always spell it wrong. Oh, yes, I got it right. Desuetude. Damn it. That took a second for the squiggly to pop up. There it is. I always spell that word wrong. Desuetude. And it's the idea that if a criminal law is not enforced, that it basically loses its vitality.
Sure, yeah.
Right? That if you don't enforce a criminal law after some period of time, it's as if it's no longer on the books. And in many regards, these contraception laws were just not enforced, right? There were these old laws in the books that just no one really cared about. Same for the sodomy ban, right? The only reason Lawrence v. Texas got to the Supreme Court was we had a district attorney in Harris County who wanted to make a name for himself. His name was Chuck Rosenthal, and he went to this law school. Oh, we'll embarrass him later. Actually, it's kind of embarrassing because I always talk smack about him every semester. He emails me now. He somehow heard me on the radio or something. He's like, oh, and he asked me all these ConLaw questions. And he's like, he said in his email, I've practiced in federal court before. I was like, yeah, I know. It's like, I know. I know. I've listened to your argument. It's really bad. But anyway, the point I'm trying to convey is really crappy laws are never enforced, which is why it's hard to get a test case. Even think of Lovings, right? This was a law that wasn't enforced. They had to try and persuade Mildred and Richard, right, to try and get arrested because they wanted someone to go to court, right? The state just didn't. Really unpopular laws like this, it's hard to get a test case because the state doesn't want to enforce it. So basically, the desuetude doctrine handles it. But if you go desuetude, then you don't get a precedent like Griswold that leads to abortion. They were trying to set the building blocks in place. Yeah, Lindsay. Right? I mean, there's a reason why they work so hard to find these sorts of cases. Even in Roe, we'll get there in a few minutes, they had to basically lie to Norma McCorvey and try and nudge her to keep the child, because if she obtained the abortion, she would lose standing. And I mean, there's so much exploitation in that case. I mean, we'll get to Griswold. McCorvey actually lives in, I think, Sugar Land or somewhere in Houston. She died about 2 years ago. One of my students said she actually went to church with her. But I never met her, but she lived fairly close. But there's just so much exploitation here, right, to try and get her into this case because they need someone who actually was pregnant. Yeah, she had a sad life. It's a very, maybe I'll play the video. Do you have the Roe video or no? I didn't give it to you.
Mm-hmm.
Oh, you have the Roe video. Okay, the end with she had a really sad life. I mean, just so much anguish in her when you see her. Just so much going on.
She was living in Katy when she died.
Katy, yes, thank you. I knew it was somewhere in the burbs. Yeah, very sad life. Whenever you talk about Supreme Court decisions, you very rarely care about the people, right? But they're human beings and they get exploited, I think, for bad reasons. All right. Any more questions in the Harlan concurrence? All right, let's do Justice White. Justice White was the Kennedy appointment. He was the guy who, did I tell you about him? He was the football player. He was an amazing guy. He basically was at Yale Law School. He played college ball football at University of Colorado. I was like, I think he won the Heisman Trophy. Then he went to Yale Law School for a year. And I think he left to join the NFL for a bit and then finished law school later. He was like a remarkable guy. He's sort of this like Mr. Incredible. At the Supreme Court, they actually have a basketball court on the top floor. So the basketball court is actually above the chamber, So you can't like dribble during courts in session, but it's called the highest court in the land because it's the highest basketball court. And Justice White would always play basketball, and always would kick the butt of the law clerks. He was such a good athlete. But he was a very unique judge. We don't get people like Justice White much anymore, where he was very liberal on some issues, but on other issues he was quite conservative. He dissented in Roe, he dissented in Casey, so he had a conservative streak to him. And what he basically said is that this law is too broad, right? Nothing justifies banning what married couples do. In fact, this is irrational, right? Even if you apply a rational basis test, this is completely irrational. It doesn't make any sense. But again, this is premised on his construction of the word liberty in the Due Process Clause. Let's see if I can find the black clip. All right. Oh, here it is. Where is it? I want to play a clip from Justice Black. Where is it? I can't find it. It's all right. So then we come to the dissent. There were two dissents, 7-2. Justice Black was the textualist, right? He says there's no right of privacy in the Constitution. It doesn't exist. You'll recall that Justice Black wrote the majority in Youngstown, right? What was his position in Youngstown? Textualism, right? The president only has those powers that are given to him by statute or by the Constitution. So here he's a textualist again, and he says, I like privacy as much as the next guy, but there's no specific constitutional prohibition on this. He says, don't forget West Coast Hotel on Lochner. I'm trying to find the clip where he talks about the Lochner. Where is it?
No, that's the one where the government tried to regulate the size of local bread.
Yeah, I want to find the clip. It's actually very funny. Where is it? It's on my computer. I can find it quicker, but it's harder here. Oh, why can't I find it? Here it is. Got it. Fine. That took way too long.
Remained a rather obscure case until Griswold was decided in 1965. Indeed, Justice Black could not quite remember.
This is really funny, actually.
That's the one that held that was unconstitutional, as I recall it, for a state to try to regulate the size of loaves of bread. No. People were being defrauded, was that it?
Okay, so pro tip: if you're ever in the Supreme Court and a justice makes a mistake, don't say no. Like I don't think I'd even have the cojones to do that. That's pretty brash. Like, no, that wasn't it. That wasn't the case. The case you're thinking of, the J. Burns Bread Company case, was a different case about the government regulated the size of loaves of bread to prevent fraud. That if you buy a loaf of bread, it has to be X ounces, right? That way they can't give you a smaller one or a bigger one. All the bread was the same size. Okay. Why is that important? If you bake bread with industrial machines, you can slice the bread with precision to get the weight precise. If you're baking bread in a small bakery, like Lochner would use, you don't have those sorts of precise machines, and maybe some bread's heavier, maybe some bread's lighter, and you can't make the same loaf of bread. So this is protectionism legislation, right? This wasn't actually for helping people prevent fraud. It was to make sure that the smaller bakers couldn't make bread that fit the criteria. Because if you're baking bread by hand, it's hard to get exactly right. If you have these machines, you can chop it in just the right way. Anyway, I always chuckle at that clip because Justice Black wigs out over Lochner. I can't remember the facts.
So there is a bread loaf.
Yeah,
case.
it was a different case. Yeah.
What was the holding of that one?
That the state could, I think they upheld the law. It was called the J. Burns Bread Company case. J. Burns Bread Company. I'm pretty sure that. Oh, they found it was unconstitutional. That's right. It was 1924, so they were still in the era. Yeah, they found that the mandate on the weight of the bread was not necessary to prevent protection against fraud, and it was a violation of the 14th Amendment. So it was another Lochner era case from 24. I think this was, who wrote the majority in J. Burns? I haven't looked at this case in a decade. I did some research on it for Professor Bernstein back in the day. Oh, this was Justice Butler, one of our favorite horsemen. And so he did Holmes' dissent. Of course he did. Of course, Brandeis and Holmes dissenting. I don't even have to guess, yeah. The purpose of the law is to protect buyers from short weight and honest bakers from unfair competition. It's reasonable. You can just, wow, the dissent's basically the entire opinion. Okay. Now, there was a case which you confused. Okay, anything else on the Black dissent? Justice Stewart, Potter Stewart, he was famous. He was the guy who said of obscenity, I know it when I see it. Not pornography, obscenity. Pornography's fine. Obscenity is really bad porn that goes to certain offensive levels. And he says, I know it when I see it, which is not very helpful to anyone else except for him. But he thought that the Connecticut law was uncommonly silly. But there was nothing wrong with it. He would later in Roe basically change directions and say, you know what, I was wrong. We can do substantive due process. He sort of accepted it. All right, so any question on the opinions in Griswold? This was a very important decision, not for what it said, but for the transition, the pivot it made to shift how the courts review legislation that runs afoul of the due process clause, that this presumption of constitutionality now changed. Yeah.
1965.
Here, I'll just play this, the clip at the beginning.
Following the New Deal, the Supreme Court applied the presumption of constitutionality when reviewing state and federal legislation. This approach severely limited...
Okay, that's it. Okay, that's just more. Okay. Eventually, I'll figure out the right way to incorporate these videos. I don't quite know. It's sort of weird playing a video of myself in class. I don't know how I feel about it, but it's good stuff and explains it in a very visually appealing way. I gotta figure it out. Still thinking about it. I got the third round of proofs today after I reread the entire book again this weekend. 330 something pages. I'm almost done. It's the last time I'm reading it. After that, I'm never reading it ever again. Till the next edition. You know, your weapon, your casebook, I reread the entire casebook to find edits, start to finish. Randy's going to murder me when he sees my edits. He's going to kill me. He doesn't know yet. There's a lot of stuff in there that might not read well. It'll read better next edition. One pro tip. When you use the word this or it, make sure you have a noun after it, right? If you use the word this, I don't know what you're referring to, or that. If you ever use the word this or that, make sure I know what noun you're referring to. This book, or that argument, or that position. This or that. The other one is it. If you use the word it, only use it once in a sentence, because it works because it this, right? What's it? You know, you use the word it multiple times, and the sentence doesn't make sense. So this, that, and it are my hated words, and every time you see it in this book, there's going to be a red line through it. The court held this. This is what the court held. What's this? The previous sentence may not be clear. Anyway, the little pet peeve, but this or that, there should be a noun after it without fail. If you don't, then you're imprecise. And most people break this rule all the time. The Supreme Court does it nonstop. And I had an opinion recently where the failure to describe what the noun is, I think, changed the meaning of the sentence. I didn't know what it was. You have to guess. Right? When I try to write, I try to eliminate any ambiguity, that there's no doubt what I'm saying. That you don't say, well, maybe it's this or that. At that point, I failed as a writer. You have to know exactly what I'm saying. So I write every sentence with that in mind. That's why I'm very persnickety. Okay. All right. Okay, any other questions on Griswold? Let's move on to Roe. Roe is one of those cases that doesn't really need an introduction, right? Everyone thinks they know what it's about, but they actually really don't. You know, you always see these polls on this, you know, on the news. Do you support overruling Roe v. Wade? Yes, no. These polls are insane because no one knows what Roe v. Wade actually said. And you probably didn't know until about a couple days ago when you read this case for class. You know, I was talking to my mom recently, and she thought that if Roe v. Wade's overturned, abortion becomes illegal in New York, where I'm from. I was like, no, Mom. Even if Roe is overruled, states can still provide protection for abortion, whatever fashion they want. They're not prohibited from doing so. She's like, really? I'm like, yeah. Oh, I didn't know that. So when people do a poll, should Roe be overturned, they're thinking that it'll be illegal nationwide to have abortion, which is not even accurate, right? They don't even recognize that Roe permits abortion in certain contexts and prohibits in other contexts. So whatever a poll says, Roe this and Roe that, I just ignore it because people don't know what the case says, right? It's not relevant. The questions that are relevant is, should abortion be regulated in this trimester, that trimester, or that trimester? Those polls I think are actually meaningful. And those polls is usually pretty robust support for the third trimester and less so in the first one, and the second one sort of in the middle. But any poll that you see with Roe, and I just throw away. It's useless because people are ignorant about the case. It's not their fault, but it's not something they learn about. Okay, let's walk through Roe. All right, so let's just go back into people. I've been talking way too much. I hope you haven't mind. You want to give me the facts, please, Lindsay? I think you're more or less next.
So Roe, who's also Norma.
Oh, by the way, Justice Blackmun, who wrote the majority opinion, had a sense of humor, and he apparently had a T-shirt that said "Row, row, row your boat." No, I'm sorry. No, I'm wrong. It said "Row, not Wade," with a guy like swimming and or something. Or no, what the hell was it? It had a T-shirt or something. Oh, I think I said it wrong. I want to make sure I get this right. I think it was Roe. Here it is. No, what was it? Oh, he had it. Yeah. He had a T-shirt that said Roe, R-O-W versus Wade, and there was a cartoon of a man rowing while another was wading in the water. All right, go on. All right, sorry to interrupt you.
This was her third pregnancy, and she wanted to have it terminated by abortion. And at the time, Texas law prohibited abortions except to save the pregnant woman's life or in cases of rape. And it was a test case in which her attorney argued that she was being denied a right to an abortion, and she actually ended up having to carry the baby.
Okay. Very good. I alluded to this earlier, but the facts are not. The lawyers in this case don't look very good, and you can be the most ardent feminist, pro-life or pro-choice person, and just recognize that this case arose in I think unfortunate circumstances for Norma. She had already had, I believe, 2 children before. Both were put up for adoption. She got pregnant a third time. She was looking to get an abortion, and there was a clinic that shut down, and she was basically asking around. And these 2 lawyers were put in touch with her somehow, and they persuaded her to keep the child because they needed a test case to file the injunction. She eventually did give birth and put the baby up for adoption as well. Later in life, she came out of the closet and said she was gay, but then when she became sort of a born-again Christian, she dumped her girlfriend. So just this person had a very chaotic life. One small point. Generally, you can only challenge a law if you're injured by it. And the only people injured by this law were pregnant women. Great. One of the aspects of being pregnant is eventually you're not pregnant anymore. One way or another, A pregnancy will not last more than 9 months, give or take. Right? It can't. Getting a case to the U.S. Supreme Court will always take more than 9 months. So what would happen if by the time this case gets to the courts, the child is born? Think of the case involving affirmative action where the person already graduated. So the court basically created an abortion exception to standing law. It's a doctrine called capable of repetition, yet evading review. Capable of repetition, yet evading review. I wanted a student write my evaluations. I make too many typos when I type. I was very disturbed by that. Get a grip. Anyway, but capable of repetition and evading review. The idea is if there's some problem that occurs over and over again, right, repeats, but because of its short duration, it evades review, the courts will still have the ability to hear it. So even though Norma McCorvey, Jane Roe, had given birth by the time the case went up to the court and the child was put for adoption, she was still able to challenge the Texas abortion law. Okay, everyone with me? All right. It's unclear exactly whether she would have even been able to have obtained an abortion because she was raped. Or she wasn't raped, but she said she was raped. I've looked into it. It's not entirely clear if Texas had such an exception. The Texas law did have an exception for the life of the mother. Let's be precise what that means. Life, not health, life. What that means is if you continue this pregnancy, will you die? If you were going to die, then they'll let you have a termination. But if it's merely, it might make you sick, it might give you health problems, maybe you'll have high blood pressure, hypertension, what's it called? Pediatric diabetes. What's that? Thank you. Gestational diabetes. I should know this. Went through this. All right, gestational diabetes. Well, we don't have it, but I read lots of books. Gestational diabetes are all these conditions that do afflict pregnant women that could be very dangerous. Hypertension. Even some people carrying a child to term, the delivery might in fact be fatal if the person doesn't have the right bone density. There's like a lot of factors in which a mother's health may be affected by it. But this is life of the mother, right, specifically. So the case was brought, and Chelsea, walk me through, they discussed a little bit how the lower court ruled in this case. It's sort of like a potpourri, right? Well, what was the basis of the lower court's ruling in this decision?
I'm sorry. I usually write down procedural history and I didn't this time.
That's okay. I'll come back to you. Do you have it, Tyler?
It's protected by the 9th via the 14th.
What does that even mean?
So the Texas statutes, I think they used the term unconstitutionally vague.
Mm-hmm.
It was very general in terms of prohibiting the procurement of abortion,
Mm-hmm.
but as it relates to what right it was intended to protect and how that was the appropriate means, there was not enough specificity.
Yeah, effectively the court incorporated the Ninth Amendment. This was, I think, Lindsay's question a few minutes ago. The court said that the Ninth Amendment also limits state laws, not just federal laws. So it's reverse incorporation. In the same way that the Due Process Clause can incorporate the right of free speech, the district court held that the Due Process Clause also incorporates the Ninth Amendment, which speaks of unenumerated rights. This is basically saying we don't really care, right? Like Melania shared, I don't really care, do you? The base of this ruling is largely irrelevant. It doesn't matter. What matters here is the sort of framework they put together, but the actual reasoning is largely unimportant. The beginning of the opinion, Blackman has this passage, and I alluded to it earlier this semester, but I'll read it. He says, we forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitude towards life and family, of their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and conclusions about abortion. In addition, population growth, pollution, poverty, and racial overtones tend to complicate and not to simplify the problem. I'll come back to you, Chelsea. What the hell is that? Every year I read like, what is that? What the hell? What's going on there? What's he saying?
It seems like he's saying that wasn't there an overpopulation in the 70s?
Yep, there was a fear we've run out of resources.
And it seems like he's saying if that starts to happen, then abortion might
We'll need it.
be the answer, yeah.
Yeah. What he's effectively saying is, if we have too many people and too much pollution and too much poverty, then abortion might become a necessary means, and we don't want to exclude that option. It's a bizarre statement, right? Every year I realize, like, what are you thinking? But then the next sentence he says, but we have to decide this based on the Constitution, free of emotion. And it's like, oh, come on. You can't go give me that wind up and then drop me down. And the next sentence he cites who? Holmes, right? He goes to Holmes. He cites Lochner. The Constitution is made for people of fundamentally differing views. And the accident of our finding certain opinions natural and familiar ought not to conclude our judgment. Again, Justice Holmes upheld forcibly sterilizing women. This is not the guy you want to cite here, right? I mean, this is not the guy who wrote Buck v. Bell. This is who you're citing. It's such a bizarre introduction to the opinion. The entire opinion I cite, I always find strange when I read it. In fact, there was a book published maybe 10, 15 years ago called What Roe Should Have Said. And the premise of this book was you had these really smart law professors who rewrote the majority opinion in Roe based on what law exists in the 70s, an opinion that actually made frickin' sense, right? You know an opinion's in trouble when really smart law professors have to rewrite it and say, here's what they should have said, right? Because the opinion itself is not well respected as it's written. I'll give you another one. What Obergefell should have said. You notice for all these very important, they don't have the cover of it yet, but there's a book. I don't have it yet. But they have to basically rewrite the opinion because what's written is like not very persuasive. Okay. All right, so for the standing, capable of repetition, evading review. All right. Just walk through it. By this point, the court has more or less had a bunch of opinions discussing a right of privacy. And they say that the right of privacy is not mentioned in the Constitution, but it's protected. Question, how does privacy extend to things outside the bedroom? Right? This is a public facility. It's a hospital or a clinic where there are doctors and nurses. It's not something between a husband and wife. It's quite private. I mean, granted, a stranger can't walk off the street to a clinic while a procedure is being performed, but it's not privacy in the same sense. So the shift is privacy in the sense you're alone in your bedroom to privacy that the government can't bother you, right? It expands privacy to a different level that there's certain things which the government simply cannot intrude upon. So it's a different conception of privacy than in other cases. What's the basis of this right of privacy? It doesn't really matter. They say whether it's the 9th Amendment or the 14th Amendment, the concept of personal liberty is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. That's the crux of this issue. Okay. Now, is this a right that's absolute? Can a pregnancy be terminated at any juncture during the 9 months? This is where the court begins to actually lay down fairly bright lines. Usually when you have judicial decisions, they're very fuzzy. This case is perhaps the outlier in that there are not quite concrete, but fairly rigid rules. And the rules are premised on the fact that a pregnancy is 3 months, and we have what are called trimesters. A trimester is a 3-month period. So you have month 1 through 3, 4 through 7, 8 through 9. My math, I can never do math. It's 1 through 3, 4 through 6, and 7 through 9. Okay, thank you. You have these 3 periods that you have these rules. Okay. Let's talk about the first trimester, right? I can't remember who's next. Tyler, you next?
Sure.
Okay, Tyler, walk me through the rules in the very first trimester.
First trimester allowed states the deference to still license physicians that could perform
Okay.
the procedure without the state's interest of the fetus considered, as in they couldn't restrict during trimester 1.
Okay, so during the first trimester, the state can enact its usual sort of health and safety regulations. You have to go to medical school, right? You have to have, surgical standards. But the regulations can't be targeted only at abortion providers. They have to be the generally applicable medical standards. Now, Tyler, one more point. During the first trimester, can the state enact a law for the purpose of protecting the life of the fetus?
No.
No, it cannot. And this was an important aspect of Roe. During the first 3 months, the state has no interest in protecting fetal life. Now, the court sort of squibbles on the question of, is a fetus a person? Right? They don't really address that. They say we don't really need to. Right? They sort of punt on that question. But even if the state decides that a fetus is a person during the first 3 months, for purposes of the Roe framework, it does not matter. Right? So effectively, from month 0 through 3, there can be almost virtually no regulations. Now, a lot of women may not even know that they're pregnant until month 2 or 3. Pregnancy tests today are a little bit more accurate than they were in the 70s. You can test earlier. You can do the pee on the stick thing, right? But for a lot of women, they may not even know they're pregnant until the 2nd or 3rd month. So this sort of unencumbered period is fairly brief, right? I mean, it's but it's very hard to even terminate a pregnancy that early unless you even know you're pregnant. Because if you don't know, you're not going to get the procedure done. Now there exist various emergency contraceptives that can operate, right after the fact. But I don't think those existed medically in the 70s. I'm not sure. No. Okay. All right, Lindsay. Second trimester. What are the rules that Justice Blackmun lays down?
That the state has an interest in both the mother's health and the fetal health, and that they can regulate abortions, but they cannot ban them in the second trimester.
Okay, very good. Thank you, Lindsay. Right, so the second semester is the state, second trimester. I'll never forget, did you see the movie Legally Blonde? There's one line where the student objects to the word semester because it's sexist, because it comes from the word semen, like seminal. So he calls them ovesters. So the second trimester, the state can regulate abortions in ways reasonably related to maternal health. They can't ban abortions, but they can perhaps impose restrictions on it. Okay? Now the third trimester, that's months 7, 8, and 9, Chelsea, what are the rules for the third trimester?
So the abortion can be banned or regulated to promote human life.
Very good. And the big difference is this is after viability. The court more or less presumes that the third trimester, that is months 7, 8, and 9, at that point the child is viable. That is, if there was an early delivery, the child would survive outside the womb. At this juncture, the state can promote the potentiality of human life, that is, ban abortion outright, with the exception to protect the life or the health of the mother. And I add health because that's an important factor. Health can be defined very broadly. If a mother might have depression from carrying the pregnancy, that could be a factor. If you define the health phrase very broadly, then it's virtually impossible to ban. So, with few exceptions, there are not many third trimester bans that are outright bans. They're usually littered with exceptions for health in all states, really, following Roe. But what we have here is you can enact just about any regulation you need in the third trimester, but you have to wait till months 7, 8, and 9. Yeah, please.
So with that being said, my thought went to states like Maine, who are allowing nurse practitioners and physician's assistants and certified midwives to perform them.
Is that new?
This year, yeah.
I thought so, okay.
Yeah, I think California has something similar. Is there a constitutional challenge on that basis, or do we say license?
Well, the state can decide what licenses are required. I mean, for a lot of medical abortions, you don't need to have a doctor present, right? There's certain types of pharmaceuticals that can be prescribed,
Sure.
in which case basically the woman goes home and
Right.
everything happens outside the facility. We'll study that exact issue in whole women's health. Texas passed a law some years ago which required doctors perform abortions to have what are called admitting privileges. That is, they can check into a hospital in the event that there was some sort of emergency. And the record shows that the number of medical emergencies from these early term abortions are fairly rare.
Okay, so the states have the ability, even if it says physician, they can extend
Yes,
the definition.
I think so, yeah. As long as it's, and I don't want to put this lightly, but most of these pharmaceuticals can be taken and there's no medical intervention that's needed.
I think those are only good weeks like 7 through 12. There's a very small window.
Yeah, I don't know.
You need
I don't know the
anesthesia.
detail. Later on, you do need some sort of actual surgical center, in which case you have to go to a facility.
Okay, my second question was, so at this point, is Buck still law?
Well, I mean, Buck v. Bell is favorably cited in Roe. Again, when people are polled on should Roe be overruled, they think, oh, Roe means my body, my choice. No, it doesn't. That's not what it says. And if you read towards the end, when it discusses Buck v. Bell, look, it says the state can control your body. We can sterilize you. We can vaccinate you if we want to. So it's not the sort of robust endorsement of women's rights that you may have thought it was. It's actually almost paternalizing that it's women's right with her doctor, and this sort of, this sort of paternalistic thing. It's not the opinion people expect it to be when they actually read it, which is why I disregard all polls on Roe.
I was surprised that there's a small enumeration of liberty, within it, and it says upbringing one's children, marital privacy, use contraception, and then it says bodily integrity.
Yeah.
Which to me seems like that would overshadow anything said in Buck. Bodily integrity.
Well, unless a state has a countervailing interest to override it, right? In other words, even if you have this interest in bodily integrity, if the state has an important enough justification, they can override that bodily interest. They can sterilize you, they can vaccinate you. Okay, everyone with me. All right, let's move on to the dissents. Oh, Justice Stewart concurred. He basically said, yeah, about that Griswold thing, never mind. I said in Griswold that it's uncommonly silly, but I'm okay with it now. The 70s were good to him, I suppose. Free love and all. Abortion usually is a 5-4 issue, but here it was 7-2. And let me tell you, almost all the judges in the majority were Republican-appointed judges. Justice White was a Democrat appointment, but almost all the Republican judges voted. Abortion today was not what it was in the 70s before Roe. It wasn't the sort of controversial issue. The sort of evangelical movement that has opposed abortion so vigorously, sprung as a result of Roe. It didn't have that sort of salience. And indeed, Justice Ginsburg, who is one of the biggest supporters of women's rights in the world, has said that Roe may have moved too quickly, and that having this sweeping ruling that overnight struck down 40-something laws in states may have been a bit too far, and that the court moved more incrementally. I mean, the same period, the Supreme Court declared the death penalty unconstitutional in all states, and they reversed themselves a couple years later because it was too unpopular. So this law, it looks like a statute, but this case really changed things overnight in a way that I don't think justice quite anticipated. All right, so you have Rehnquist and dissent. Rehnquist says this is Lochner, right? It's sort of this slur, Lochner-phobia, right? We are supposed to use a rational basis test like in Lee Optical. The Due Process Clause gives a lot of deference to states, and this is a rational law, right? You should not invalidate this in this sweeping format. All right, you quote from Lochner, but you're closely attuned to Justice Peckham's majority opinion. States have a tradition of restricting abortion. This right is not deeply rooted in the traditions and conscience of our people. In other words, you're saying this is not a fundamental right. States actively ban these procedures. This is not like contraception where these laws are never enforced. The abortion laws are enforced. And the fact that there's some debate means that the position is not yet solidified. When the 14th Amendment was ratified, it would have been unheard of to say that there's a right to abortion. And the majority does not dispute that. And then we have another dissent from Justice White, who says this is an exercise of raw judicial power. Maybe the court has the ability to get away with it, but they shouldn't do it. They should be left to the political process and to the people. Okay, questions so far? This decision was widely criticized in some circles. John Hart Ely, a famous law professor, said, "This is not constitutional law and gives almost no sense of an obligation of trying to be law." This was like Emanations of Penumbra is like leveled up. The court would eventually clean up its abortion jurisprudence in a case called Planned Parenthood versus Casey, which you'll read in class, I guess, on Monday, where Justice Kennedy, O'Connor, and Souter don't overrule Roe, but they reject parts of it. They say they affirm it, but they reject parts of it, which is this weird split. Okay. Oh, we almost went to the end today. There's 2 cases. These are long cases. Okay. Any questions on Roe? All right, I will see you all Monday. Have a wonderful 4th of July. Read the declaration for me tomorrow. You have it in your pockets. I read the entire thing, not just an introduction. Read the entire thing, and you'll have a better evening. Thank you.